Good afternoon. Good afternoon. How you doing? We had to come in and on our lunch, breaking news, need a breaking news update. Currently, suspects still on the loose. Suspects are still on the loose in Columbus, Ohio. Um, in the case of $15,000, $15,028 has been stolen from an Ohio registered nurse on purpose. It was deliberate. Aetna Resources LLC, CVS Health Company, attorneys. Richard Diageo, he's a New Jersey lawyer. And Alex Frondorf, Ohio lawyer. Sat up here. Schemed and scammed. You know, if he's a bone from a chicken feed. Shut up. Schemed and scammed. Lied and conned the world, all of you. Allegedly. We want you to make the decision. We want you to be the judge. It's the People's Court case now. There's a case out there in Columbus, Ohio, Franklin County, Court of Common Pleas. 22 CV 7866. Filed November the 19th of 2022. Guess what? No judge has made any rule whatsoever on that case today. And today is July 24th, 2023, Monday, July 24th. 2023. The judge presiding on that case is Chris Brown. No, not the Chris Brown that we all know and love. Be singing it down like, oh, whoa, 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 whoa. Not him. We don't know who this judge is. But we want you to know that Judge Chris Brown has not made any ruling whatsoever on several pending motions that are at Franklin County Court of Common Pleas, 22 CV 7866. When you file a court case like Aetna Resources LLC, a CVS Health Company did, when you file something in the court, it becomes a court's case, the people's case. Judicial costs are involved. Oh yeah, oh yeah. But they don't give a damn, they don't care, do they? This case just sitting down there, just running up judicial costs and shit like that, went all along. Everybody involved knows it's a bogus, fake, frivolous filing. It's an interplea in which attorney Alex Frondorf, Ohio attorney Alex Frondorf, ran down to the court about this case after him and his colleague, Richard Diageo, had to figure out a way to how they could steal this Ohio nurse's this Ohio registered nurses property in the amount of $15,028. Okay, well, first what they did, first what Richard Diageo did, he sent the Ohio RA an email. And he was like, would you consent to having your $15,028 held while the fee dispute is going on between you and Spitz Law Firm? He said, because Spitz Law Firm notified me that they were going to sue me, my colleague Alex Frondorf, and my firm, the Earth Medicine DC, if we didn't figure out some type of agreement with regard to these fees. What the fuck did that have to do with the Ohio registered nurse and her fucking money, her property of $15,028? That Spitz Law Firm for Sabrina got in touch with you and said, we're gonna sue you, your colleague, and your firm. What does that have to do with the registered nurse from Ohio that you still have her $15,028? Excuse me, huh? Okay. So this is what they don't want you to know, public. You must ask consent if you want somebody's property. All right? Period. In life. You have to ask. Can I have $5, Betty? Betty, can I have $5? You have to ask. Ask her consent and see if Betty, what she says. If she gives it to you, then she consists that you have it. If she says no, that means no. If you go ahead and take it anyways, what is that? Oh, wait. You ask somebody if you can have something of theirs that doesn't belong to you, and they have to give you permission to take it. They go ahead and tell you no. You decide you're gonna take it anyway. What is that? Next, what is that? It's theft, right? So, Aetna Resources LLC, a CVS Health company, and its attorneys, Richard Diageo, Alex Frondorf of Littner Mendelssohn PC, willfully, intentionally, deliberately, and with malicious intent, stole $15,028 of an Ohio registered nurse's property. What? Richard kept asking the Ohio nurse time and time again, will you consent to this and consent to that, to hold your property and do all this? And she told him no several times. And also an email, she said, listen, I've said several times, please stop bothering me. You're exacerbating my mental health conditions of PTSD, major depressive disorder, panic attacks, anxiety. I thought this was supposed to be over. Why do you keep on bothering me? I'm looking at this as being harassment. If I have to tell you again, no. I said no. Send me my money, as you agreed, in the entire sum, the total amount, inclusive of $15,028 immediately, because you're past the deadline now. Instead of adhering to the request, Richard Diageo and Alex Frondorf took their legal expertise, right? And they devised a plan where they could utilize their legalese and all of this to put together a lot on paper of half-truths. Because what they were attempting to do is spin a narrative in such a way, in such a fashion, that they would be able to meet their own objective and agenda that ultimately what works in their own favor. right? And that's so that what that is, that action is you, Richard, you, Alex Frondor, you acting in your own best interest. Okay. Richard and Alex Frondor acting in their own best interests. Okay. That's what that is. Why do you think that they did that? They did that because by law, as they know, they're the legal experts. You must ask a property owner for their consent before you can hold or seize, take over, and commit control of their property. Without consent, if you go ahead and do it anyways, it is theft. And in that amount of $15,028, it's felony theft. So now we have two suspects on here still. Richard Diageo and Alex Frondor. What? Why is that so damn hard to comprehend? Because if it was you, if it was me, and you went to somebody's damn bank account or their purse and stole $2 damn out their purse, you stole a piece of fucking candy out their purse. They're gonna have you plastered all over the police station page, all over the Crime Stopper page. You're gonna be on Fox News, Fox 20, okay? Oh yeah, you're gonna go on every social media platform and be like, oh my God, look at what the suspect did. The suspect stole a piece of candy. We got 20 years. We need an electric chair. Make sure you forget to put the water on the sponge when you electrocute them. They stole the candy. Community, can you help? Community, here they are, the suspects. Here they go, the suspects. Could you please help us find these suspects? We need your help. Community, are you able to identify these suspects? They stole. We don't tolerate thieves. It's about being honest and integrity. We have to get rid of the criminals that steal. But that's only for you, layperson. The rules only apply to some and not all. Those rules don't apply to Richard Diageo and Alex Frondor. Why? Because they're attorneys. They went to law school. Well, Richard and Alex Frondor, they took the risk. They know and knew and understood exactly what they were doing, and they took the risk. You know the consequences involved when you do something that is illegal, and certainly you know exactly what you were doing. You know that participating in theft, and that actually was theft. See, they didn't think 2 steps ahead of their actions because what they thought was that they was dealing with a dummy. Most people do. And so we go ahead and steal this nurse's shit. We just run all over this nurse. We just stomp on her. We just keep our foot on her neck and just do whatever the hell we want to do and shit like that. Because they think that nurse is just, no, she's just a little old nurse. She don't know shit. She don't know anything. Whatever. She's such a dummy and all that. But they really don't know anything about it at all. Yeah, so that particular nurse that they stole the money from, $15,028, is pretty diverse in a lot of different areas, very well rounded, in fact, and quite the intellectual. Yeah, and far more smarter than they thought, and a hell of a lot smarter than them. And they thought she would be dummy, but look at them, space cadets. They never thought a bitch was about to get on social media and tell them they did. And guess what? She's got receipts. She got the receipts. Yeah. So, Richard Diageo and Alex Frondor of Littler Medicine PC, counsel for Aetna Resources LLC, better known as Aetna, a CVS health company, had the nerve, the audacity, and the gall to participate in an EEOC mediation hearing on October the 14th of 2022. Let's sit there and negotiate and agree to pay an entire sum, which the entire sum is confidential total amount, right? Of that, they still owe $15,028, okay? They, Alex Frondor, ran to Columbus, Ohio, Franklin County Court of Common Pleas and filed 22 CB 7866, November 19 of 2022, in which Chris Brown, as a presiding judge, has not ruled on any motion, any pleading since the filing of that. It's called lazy judge. Okay? There's no ruling whatsoever on anybody's motion for all participating parties at all. It's a lazy judge. So then the Ohio RN also sues Spitz Law Firm. Okay, so breach of contract, or she had to terminate them. She terminated them prior to the EEOC hearing. All right, just a quick snippet. The reason why they've been terminated is because the Ohio RN actually had been pro se all along. Okay, she put her own blood, sweat, and tears into her own cases. Okay, she filed an EEOC charge on her own. She filed a civil rights charge on her own. Spitz Law Firm did not file any of that. She spoke to anybody she needed to about anything investigatory and providing any type of information and sending over any type of documentation that anybody investigating those particular charges needed herself. Nobody did anything. She also filed a federal case in the U.S. Southern District here in Columbus, Ohio. So she filed that particular federal case against the respondent in the EEOC charge 532-2022-02705. So she also filed every pleading, every motion associated with the federal case that she filed as well. It's easily verifiable. You can just go and look it up. Maybe we'll come back when this is done and put the case in the comments. Yeah, so she filed that particular case, and you can just go and look at it, and you'll see that there's nothing filed by Spitz Law Firm on the case docket other than a motion to appear and then a motion to withdraw. All right. So the plaintiff in that particular case at the federal level also had to file her own affidavit of indigency, put her own financial disclosure statements in, serve the complaints and everything on the parties that need to be served the complaint. I mean, spend her own money and things like that, and the expense associated with the mailings and the copying and the research and everything that was involved. Yeah. This particular RN, as pro se, had to conduct her own truth-seeking process, which is discovery. Spitz, did you do any discovery on behalf of this particular Ohio registered nurse? You should be able to show that. You should be able to show it. Did you send any letters out on her behalf? Say, excuse me. The only letter that Spitz Law Firm actually did send out on the Ohio RN's behalf was an initial demand for settlement letter. That's it. Okay, that's it. That's all. Does that cost $15,028 for them? Damn. They never sent anything to Whitner Mendelson PC requesting anything, the personnel record. They never sent anything. Now, the Ohio RN has everything. She has everything she's ever sent Whitner Mendelson PC, every email, because the only person she had communication with from the time she started requesting things, okay, through the counsel for the respondent in 532-2022-02705, right? She has all the correspondence. And of course, Richard Diageo, why would he lie about that? We have it all in writing. He never heard a damn thing about Spitz Law Firm. He was already talking to the Ohio RN as pro se. And they were sending the communications back and forth. Filings were already made in the court docket at the federal level, right? Yeah. So a multitude of employment claims existed that we don't need to get into, okay? None of those employment claims that existed, the Spitz Law Firm filed anything on behalf of the Ohio RN pro se. They won't be able to show it. They won't be able to demonstrate it because it didn't happen. Okay. But what Spitz Law Firm did do is go down there to the Franklin County Court of Common Pleas and submit something stating that they had over 200 documents. Well, of course you have over 200 documents because that's all of the Ohio RN's discovery and evidentiary work, right? Truth-seeking process type of work and everything that she's participated in. She had to gather the employer statement. Is everything associated with all the employment claims all together, all the work of the Ohio RN as pro se. That's all the documents in it. There's no document whatsoever that they ever petitioned Whitner Mendelson PC for or anyone else on behalf of the Ohio RN pro se and obtain. It's true. It's true. They haven't done anything. What they did do, though, however, was send an initial demand for settlement Greg Schumacher of Spitz Law Firm. He gave the Ohio RN a call and said that he was going to do that. But that was the last time the Ohio RN ever talked to him, ever again in life, even through this day, never talked to him ever again. He sent that letter and nobody ever called that Ohio RN back and said, this is what the other party said. The Ohio RN pro se was employee. Aetna Resources LLC, a CVS health company, was the employer. Spitz Law Firm sent the demand letter over to them, the initial demand letter. The Ohio RN, the employee never heard anything again about what the employer said post the receipt of that initial demand. What did they say? I mean, did they say, what did they say? Did they say, okay, that's fine? Did they say no, because this is all the evidence that we have against her as an employee that shows why we're not going to pay that much? Did they say that? I mean, what did they say? Because the Ohio RN pro se is still waiting to this day, July 24th, 2023, for the information and the communication back on what the employer had said after you sent the initial demand letter. Do you know? I mean, could you tell me, Spitz? What type of work were you doing on behalf of the Ohio RN pro se? No, what Spitz Law Firm was doing was work on behalf of themselves in their own best interests, right? Because that's what people do. And we had to figure that out because then out the blue, months later, after the RN had already done all of her work. See, the RN had already outreached Spitz Law Firm long ago before even the termination occurred from the employer. And Spitz Law Firm said they cannot take the case. They need to wait on adverse action to occur. And they were looking at all the retaliatory shit and whatever was told that was not, that's not considered retaliatory. They have to, fire you or something. They have to put some type of performance on you or something like that. So once the employee was actually terminated, that's when the Ohio RN pro se outreach Spitz again. But all in the meantime, this RN all along has been documenting and gathering all the information and everything that is necessary, all right, to prove a particular case, especially these types of cases. So that's the RN going through the shit, the severe harm, okay? And having then also to research and put in her own blood, sweat, and tears into her own case because nobody want to take the case until something bad happens, right? But then the Ohio RN did outreach Spitz again. Said, hey, I've been fired. Would you consider again? They said, yeah. Based on the contract and everything, they was going to work in the client's best interest, the client being the Ohio RN pro se, right? That's what they said they was going to do. What did they do? What do lawyers do? They file claims in courts. They file motions and pleadings and briefs and things like that in courts. They participate in a truth-seeking discovery process. Sometimes, that does involve sending letters and things like that. Yeah, so they sent an initial demand for settlement letter. But what else did they do? What else did you do, Spitz? Of those 200 documents, what documents are actually yours that you obtained by your own efforts on behalf of the client, the Ohio RN pro se? Oh, nothing. Oh, she has sent them all to everything that she had. She sent it all to the email. She even separated all the exhibits and she's numbered them and stuff like that and sent them to you. She did. It's easily, you can prove it very easily. Just pull all the emails out, see it like from Ohio RN to Spitz Law Firm and have all the attachments. It has everything. Like most of it had already went to the initial intake person, Nick Kerr. But then Greg Schumacher called and he acted like he didn't have none of the shit. So you already knew they was unorganized, kind of like, didn't Nick give you all the shit? So then you had to resend it all again to Greg Schumacher, all right? And you never heard nothing else from him after the date that he told you that he sent a letter over to the employer, demand for settlement letter, right? Never heard anything else. And all of a sudden, 2-3 months later, here goes somebody that sent you an email you ain't never talked to, ain't never met at all, talking about what is your employment status at this particular time. Mhm. And then so on the email, the Ohio RN Pro Se says, I'm sorry, who are you? I don't believe we've ever met nor spoken. And then what happened? So then this employee over there says, oh, that's right. No, we haven't. No, we have never met. We've never spoken. My name is Trisha Breedlove. I'm the attorney that's negotiating I've been negotiating your settlement based on what's in the file. What she's talking about is what's in the file is what was provided on initial intake to Nick Kerr, through just verbalizing answers to his questions and then sending over everything that you already have to him. That's what's in there. Trisha Breedlove never outreached the Ohio RN Pro Se and asked any questions about any of the documents, never asked any branching questions. Like I see here on this date that XYZ occurred, never asked like, so is there any issues going on? I mean, have you ever been, like reprimanded? Have you never? But what are you negotiating? I mean, what are you and that employer over here fucking talking about? I mean, I don't even know. What happened after the initial settlement letter was sent to them? Nobody ever called and said, or tell me what they were saying, give opportunity. And negotiation involves both two parties, and then it's a lot of refuting and rebutting or showing evidence and proving your side and your point and shit like that. Ohio RN Pro Se never got that opportunity. So what the fuck are you over there talking and negotiating with them about? I mean, because you don't really know shit. You go off some bullshit you got in a folder. So quit playing, quit lying. All right, this is what they're doing. They're playing in their line. They all need to be reprimanded. Yeah, and this is what is representative of the bar. All right. So one of the attorneys, Richard Diageo, is a New Jersey attorney. All right. All right. A grievance was already put in on him and nothing's been done. All right. So I don't understand that. These are suspects. And so $15,028 of an Ohio nurse property. All right. They know the nurse is the rightful owner, rightful beneficiary. They know they owe it, all of that. And they did it on purpose to hide what they were doing, their own wrongdoings, ill will and wanton actions and things like that, important behaviors, okay? Violations of their own professional and ethical conduct and stuff like that. And what the bar said that they need to be doing it here, like they violated that, right? But they want to cover it up. They don't want you to know. But they want to do that at the detriment of the Ohio RN, all right, who's been wronged severely. Okay. And now the $15,028 that's stolen is out in oblivious somewhere. No one knows where it is. No one knows where it is. EEOC, Thomas Koplow, the field director, notice it, field management director, he wrote a letter on February the 1st of 2023 outlining that since Aetna had placed the money in the court by Ohio law, the funds are out of their hands, okay, and no longer in their control. And so that is why EEOC, US EEOC, Cleveland Field Office or any office will not get involved and intervene on the fact that they know, okay, the EEOC MSA agreement has been breached. And they also know, they actually know that $15,028 is not in any court. So that's Thomas Koplow just talking out the side of his neck. He's not an attorney. He has a master's of arts. Excuse me? What are you talking about? Okay, he's got a master's of arts and like a bachelor's in business or some bullshit. The Ohio RN has a master's in business, bachelor's in nursing, is a legal nurse, is a life care planner, has a degree, an associate's degree in applied science, computer science, hardware installation, software management, okay? Hardware and software management. And then she's also got an associate's in arts, which we know anything in arts it doesn't equate to anything. It's like prerequisites. It's like the bullshit that you go and you do just so you can get a degree because you don't really want to put in a lot of work and doing shit else. It's just some bullshit that you do as a prerequisite or preliminary before you move on and you really got to hone in and focus on the real deal and the real shit, okay? That's really what it is. But see, these dummies out here, they don't understand that Ohio RN is the true expert and has the true expertise, not just in nursing practice, but a lot of different areas. very well-rounded, and she set it up that way in her life, so she could be. Because actually, this person is really just an overall advocate for people in general, but primarily the people in vulnerable populations and things like that. Yeah, that people like these that we're explaining to you today continue to hurt and harm intentionally and deliberately. All right, and create obstacles and things like that for them. All right, so what? They can make their own agenda and keep their foot on these people's neck and things like that. The RN included, all right, while they're already going through a hardship, all right, mental anguish and stress. In this particular case, someone's livelihood was snatched from them, like their job, But you can be the judge of that now because even though you can't know the total settlement amount, Aetna Resource LLC, Alex Frondor, Bridget Diageo of Littner Mendelson PC wanted you to be involved, and they wanted you to at least know, because they filed the case, they at least told you that $15,028 you're still owed to the Ohio nurse. They admitted that what they know that they do. They didn't admit that they actually do know that the RN is the rightful owner and beneficiary of that bill, and that they actually themselves, Richard Diageo, attorney for Aetna Resources LLC, a CVS health company. He works for Littner Mendelson PC. What he failed to do was tell the whole truth and nothing but the truth. He told the half truth on a spun narrative to make it look good on paper to the public, or perhaps a particular court, the lower tier court or a higher court, that says, oh, this makes perfect sense, and finding case law and things like that to, where there was already an opinion and trying to make it applicable to the instance. Well, but it's not true. It's actually a lie. You're leaving out key points there, though, Alex Rhonda. Okay, so what Alex left out was the fact that it's true, we have receipts. The fact that Richard Diageo, what he actually did was, and also Richard Diageo and the EEOC mediator, Salvador Lopez is his name. Oh, EEOC has awareness of this too. They know what their own mediator did as well, right? Him and Richard Diageo over there playing games or doing whatever they're doing to conjure up something to trick the Ohio RN, who already notified both of them. The EEOC mediator, Salvador Lopez, already knew about a fee dispute anyways, at the point that the Ohio RN EEOC charging party had fired Spitz Law Firm. She had already told Salvador Lopez. Salvador Lopez, mediator, he took it upon himself without consent from the EEOC charging party to call Spitz Law Firm and talk to Tricia Breedlove and call himself negotiating that. That doesn't have anything to do with EEOC mediation, but that's what Salvador Lopez did. But then he was so dumb, he called the RN pro se and told her, the EEOC charging party, yeah, I called Tricia over there and they just want to get their fees. He's trying to mediate that, and he has nothing to do with it. Okay. Because he says he knows Greg Schumacher. Okay. So yeah, don't trust EEOC and that, they're mediators and all that's really on the side of employees. Well, who told him that he could call over there and talk to them and say, who the fuck does he think he is? Who the fuck does he think he is? And EEOC knows all about it, and they're not doing shit about it, okay? They're trying to sweep it under the rug so the public doesn't have any awareness, and that's what they do. But your time is up, and I told you, time is up, wrongdoer, right? Absolutely. All right, so what happened was, Richard Diageo and the EEOC mediator, Salvador Lopez, he's really on the side of Tricia Breedlove and Spitz Law Firm, and he's over there calling them behind the scenes, doing all this. So he's trying to play a game and trick. He wants to ensure that they get their fees when he already knows that's a separate dispute. That's something between those two parties. He shouldn't be doing that. He knows that they've been fired. Okay. He knows that they were fired. All right. And he shouldn't be having any discussions with them because it's over. It's said it's done, but yet he's still having discussions with them. So at the point of the EEOC hearing on October 14, 2022, the pro se RN had no representation of counsel. And in fact, no counsel person whatsoever from Spitz Law Firm or anybody else even took all those documents, like those 200 documents that Spitz Law Firm claimed in their what they sent to the court and 22 CV 786 they claimed they had. None of those documents were uploaded to the EEOC portal by anybody from Spitz Law Firm, not Greg Schumacher, not Trisha Breedlove, not Brian Spitz, not none of them. All right. The charging party uploaded all her own documents, all right, and did everything herself outside of sending an initial demand for settlement letter. All right. So Spitz Law Firm was fired on September the 25th of 2022. All right. The EEOC hearing, which Aetna Resources LLC did agree to participate in, all right, what it did, it brought us back to the table. So whatever the fuck happened over there with Spitz didn't matter. All right. So the Ohio RN did our own negotiations with the mediator and the respondent. All right, everybody came to agreement, all that, and nobody was supposed to be. Nobody should have had any questions about any fucking thing. It's all said and done. But Aetna Resources LLC, we're not even supposed to be litigating the matter or talking about it. But then Aetna LLC goes and files a court claim in the court, which makes it a public case. Now you just opened up a whole can of worms because you have to go back and talk about everything now. And really, we're not talking about everything. We're not talking about everything leading up and stemming to what led to the filing of a claim anyways. However, in the court of common pleas, there is a picture that's been painted, all right, that has to go back and tell it because as a third party, no judge can sit as a third party, not taking either side, non-biased, okay, and not have a complete picture painted of everything from very beginning through all the steps leading up to the point that they're in court if you don't tell it all. All right. Now, we can't tell you people in the public the total confidential settlement amount, but Aetna came and told you $15,000, $20 million. It's still out there on the book. All right. So you can know that. You can know that they owe it. They know that rightful owner. Right. And all of this, that interpleader case that's down in Franklin County Court of Common Pleas, 22 CB 7866, it all stems from employment claims. It all stems from an EEOC charge. Okay. It stems from a lot of employment claims. But this particular charge right here is what during the mediation hearing led to an actual settlement for a total confidential amount in which now there's a balance of $15,028. Okay. So what was really happening with EEOC mediator Salvador Lopez and Richard Diageo, they were scheming and scamming and doing whatever. They were somehow going to try to really make sure the Spitz Law Firm received $15,000. They were going to figure out a way. So they were attempting to trick, all right, at least for sure, that damn Salvador Lopez from EEOC was to trick, all right, and coerce the Ohio RN to sign that shit. But then, you know, Ohio RN is like, you ain't allowed to do that. I'm about to turn you in. Fuck that shit. Get sick of this shit. You're trying to trick, I'm not going to tolerate it. No, you know what? You already know about what's going on with the fee thing. You're not going to put that in there. You better get that out of there or there will be no agreement whatsoever. Period. Because I'm going to turn you in. So she told Richard Diageo this because both of them, Richard Diageo and EEOC mediator Salvador Lopez, they wrote up these initial agreements. There's 2 agreements in EEOC, right? EEOC agreement is called MSA agreement. Then the employer will write up another agreement. It's a separate release agreement. EEOC doesn't have, you know, any enforceable power over the separate general release, but they absolutely do have power over their own MSA agreement to enforce it in any breach thereof. They are aware of the breach. They are aware that the property of their Ohio RN EEOC charging party has been stolen. It clearly states in both agreements, which they do have a copy of it, even though they can't enforce it, they have a copy of it. So that if they were actually doing any real research, like Dylan Gaka and Nanisa Perez from EEOC end up calling the Ohio RN Pro C and telling her that, you know, over the phone that we did some research and what we could offer you is that you could file another retaliation claim because the money is with the court. And there's nothing we could do as far as that's concerned. And they were told at that time that the money is not with any court. The money is not in any trust account. And in fact, the money is not even with a third party, innocent third party that doesn't have ownership or interest in the money. All right. So I don't know what type of attorneys these are and what they're trying to do. and shit like that. What they're trying to do, they know exactly what they're doing. They know that this is a fake bullshit ass interplayer. You have total ownership in the fucking money, motherfuckers, coming out of your damn revenue. You owe it as an alleged wrongdoer in an EEOC fucking case. You can't just keep holding on to somebody's fucking property and you're the motherfucker that owes it. That's like, I'm like, the Ohio RN should turn you into collections. You need to be turned into collections. Just like a business entity will turn you into collections when you owe them $15,028 on your house note, for example, and you haven't paid them. They keep saying, where's my money? Where's my money? Where's my money? You haven't paid them, they can turn you into fucking collections. You owe it. They owe it, but this is a different situation. What they really did was steal it. And they stole it on purpose to cover their own costs, right? So Philip Kyle from EEOC, he's the Cleveland Field Director, and Namisa Varela, she's the program analyst there. They called on the phone. They said, go ahead and file another retaliation case on. We can show you how to do it. It's all in email. All right, it's all in email. Okay, there's proof that it happened. And that's why I tell everybody out here in the world, them fucking telephone calls when they call you on the phone and shit like that. Say, oh, okay, can you provide that in writing? Can you provide that in writing? They're not going to provide anything to you, right? So what you do is you email them because this is like a governmental agency, right? You email them through their governmental shit. All right. All right. They better not try to erase one of them emails or nothing like that. You put it in writing because they're playing games. And they're trying to trick and slick and hustle and everything like that. They must have never hear about me. This ain't the first time. This happens all the time. And it's going to stop because if it's happening to me as the Ohio RN, that's pro se. Trust and believe it's happened to a lot of other people that don't have the wherewithal. They don't know, they don't see it, they don't have that sense of discernment, or it's never happened to them before and they've had to learn with time. They don't have the skill set that they have to self-teach themselves in order to barely be able to battle against this shit because no attorney is going to take this type of case. It's very complex. Or if an attorney does happen to come along and take this type of case, like Spitz Law Firm did, where you did all of the work, what do you believe they're going to do? They'll say, oh, wow, ching, there's really nothing that we even need to do. But she did it all, and we don't even have to tell her shit. She's a whole dummy. I mean, we'll send a demand letter. We'll just sit over here and get some little settlement best we can. We just keep talking to them ourselves. We won't never call her. We will never communicate with her, keep her and what's going on. We won't give her opportunity to rebut or refute anything that they're saying or nothing like that. And we'll just come up with a fucking settlement. And it can just be whatever, and we'll just get paid. And who gives a fuck about her? Who gives a fuck? Who cares? We're just finding our own best interest. We don't do that, and we don't include her in the loop. We don't have to work in her own best interest. We work in our own best interest. That's what we do. She's so dumb, she ain't even gonna say nothing about it. Well, whatever. Bottom line is, it's the case down there at Franklin County Court of Common Pleas in Columbus, Ohio. It is running up judicial costs. It is just sitting there. It's been sitting there from November 19 of 2022. All right, Chris Brown presiding. Now, the Ohio RN also is suing as a plaintiff on Spitz Law Firm in one case, and they're also suing Aetna Resources LLC as the plaintiff in an alternate case as well, in which Michael Holbrook is presiding over both of those cases, and all the cases together, all three have been now consolidated. So neither Chris Brown nor Michael Holbrook have made any type of ruling on any other pending or outstanding motions or pleadings or anything like that. It's running up judicial costs. It's actually taxpayer money is of public interest and public policy. You should know exactly what that court is doing. Yes, you should. That's Franklin County Court of Common Pleas. So the Franklin County Clerk of Courts knows as well what is going on with this particular case. And so we want to know from them, like, who the fuck you gonna charge for this shit? Who are you gonna charge? You better be charging Aetna Resources LLC, Alex Frondor, and Richard Diageo, and Aetna, and CBS, whatever, who's sitting up here playing in the court and stuff like that, and attempting to use a whole legal process that is otherwise an effective approach to figuring out who the rightful owner of a particular amount of money is, if there's a lien or, a court order or something like that. Somebody comes along later on, if a settlement has been, reached and say, hey, no, we got a lien on that or whatever. All right, so there is no lien. No lien exists. Everybody knows this, everybody. Spitz Law Firm knows it. Aetna Resources knows it. Richard Diageo knows it. Alex Frondos knows it. Whitman Medicine, PC knows it. And any and everybody that's been on any of them email threads from all the shit, they all know it. There's no lien. There's no court order. All right. There's no judgment, nothing. So they just decided that they were going to seize the property of 15,000 from the Ohio registered nurse just because they wanted to, and they wanted to cover up their wrongdoings and cover their ass and ask the court to relieve them from a particular matter in which they actually created for themselves, because they don't want to be sued by Spitz and then turn around and be sued by the EEOC charging party, former employee, Ohio RN, pro se again. All right. So what actually happened was going back to the EEOC, Richard Diageo and what's his name, Salvador Lopez. What they did, they tried to trick the Ohio RN. They tried to trick. But you got caught, boo-boo. You got caught, boo-boo. So they got caught. Said, hey, listen, you're trying to curse a motherfucker under the rest of sign and shit and everything like that. Nope, I'm not gonna agree to no type of settlement whatsoever. Don't get that language out of there right now. I'm not paying Spitz 1 red cent for all the damn work I did. How much did your fucking demand for settlement letter cost? How much did that cost? You get paid for that. That's all you did. You do shit up. I ain't gotta pay your ass for filing an appearance on the fucking federal case or filing a letter to withdraw when you didn't do shit. Lawyers are supposed to be participating in depositions. They didn't put no witness disclosure list together. They didn't call no motherfucking witness. They didn't put a legal hold on the motherfucking devices and shit like that at that place. They didn't call national personnel files. They didn't call, they wasn't communicating back and forth in any type of email or sending any letters and shit like that out to Richard Diageo or anybody at Litman Mendelssohn PC. They didn't do jack smack shit. Excuse me? And they're not going to be able to prove it. And they know it. And Richard Diageo already told it. He sent it an email to the what? Ohio RN, EEOC charging party in 532-2022-02705. He said, will you allow us to keep your money, $50,028, because Spitz Law Firm has threatened to sue me, my colleague, and my firm, Whitmer Mendelssohn PC, if we don't come to an agreement over the $15,028. Remember, I told you that in the beginning of this video. Why would they tell him to sue him and his colleague and his law firm? Think about that for a minute. Why would Spitz Law Firm tell Richard Diageo, if we don't come to an agreement over that $15,028, that you already signed an agreement that you would pay in total, entire sum, directly to the EEOC charging party by X date? We're going to sue you. Well, the reason why Richard Diageo, he had already gone over to Spitz Law Firm and he told them, listen, I got a $15,000 check coming to you. So go ahead and send me your W-9 and ship it. That's what he did. It's true. We got receipts for that too. But what he failed to do, right? Remember when I told you that what he tried to do, him and the EEOC, Salvador Lopez tried to do, they tried to trick somebody to sign a particular agreement, all right? And got caught. They tried to trick under duress, right? And we're told you better get that out of there right now. I'm gonna report you. All right. Richard Diageo, as well as the EEOC mediator Salvador Lopez, on the exact same day, voided out the initial MSA agreement and voided out the separate general release agreement that had language in it specifically allocating a dollar amount of $15,000 to Spitz Law Firm. They both have specific language in their initial agreements, MSA and also the general release, specifically allocating $15,000 to Spitz Law Firm. They had to get it out of there. They've been ready to get in trouble. So both of them voided of their own free will. We have receipts. It's all in writing. It's all in emails and shit like that. Of their own free will, they both voided it out and started over fresh, right? But Richard Diageo, he took it one step further. He said, as requested, I have taken out, I mean, I'm not quoting this, but I have the emails posted. It's posted on Twitter. Nick Dick 444. His email's posted there. It speaks for itself. He wrote it. Nick Dick, NIKDIK 444. All right, that's the Twitter handle. That their shit's pinned, so you can go look at it. All right, it's a lot of good information there if you'd like to learn from it, especially a law student. Okay? Learn what the fuck not to ever do. Okay, because it might wind you up in prison. You damn sure better not steal no money from nobody. But so he said, hey, EEOC charging party Ohio RN, pro se, just want to let you know, as you requested, all the specific language. All the specific language has been removed pretty much. Allocating Spitz Law from $15,028. Yeah, all that has been removed. All right. But you know, just to make sure everything's cool with you, I'm gonna go ahead and send you the red line draft. So I sent the draft, the .doc document, the Word document. He sent the draft to the Ohio Prison RN. All right, he sent it to her to proofread and approve. All right, and say yay or nay before he finalized the actual agreement that really does exist. And that's enforceable and things like that. And this agreement does not have any language whatsoever allocating not 1 cent to Spitz Law Firm, because Richard Diageo himself removed all of that language that he had in there initially, and he had already gone over to Trisha Breedlove at Spitz Law Firm and told her that he was giving them a check for $15,000. So that's what they left out. Of the half truth, spun narrative. They left that out. They didn't tell the court that, right? But Alex Frondo's traipsed on down there and filed an interview, knowing full well the whole story, knowing the truth. And he did it intentionally, deliberately, and willfully. He took the risk. He took the risk. There's consequences in your actions. Right? You took the risk. If you were to take the risk of stealing something from someone, you're taking the risk of getting caught. You already know you're not a dummy. You're not a dummy. Richard Diageo and Alex Frondo, damn sure ain't supposed to be dummies, right? Didn't they go to law school? Doesn't that take like additional 3-4 years post undergrad? Studying specifically law and the consequences behind the bullshit. They took the risk. They took the risk willingly, knowingly, and understanding the entire full truth, and just trying to cover up what the fuck they had done. Boom. Period. Okay. So, but Yep, so the Ohio RN, after she got the red line drafted copy in the .doc format, Word format, she went on and read it over. So okay, that's fine. And then also she also has correspondence back and forth with the EEOC, Salvador Lopez, when she said, "I'm very ashamed of you. I'm very disappointed in you that you would sit up here and try to trick a bitch, okay, and put a motherfucker under arrest and everything like that." Okay, like whoa, you're supposed to be the advocate for the employee. No, you didn't, Lopez. What's really going on with this shit here at the EEOC? Thought she was an employee advocate. Yeah, and Thomas Cocklaw, this motherfucker, go look at his shit. Like, boy, you got a master's in arts sitting up here trying to write some shit about some law. You gotta get out somebody's face. Boy, you ain't no lawyer. Go back to school. Go back to school. That's what you're trying to do. Okay. All right. I'm not no lawyer, but I got the rights. I have the rights. The liberty, the human, constitutional right to be pro se in my shit. Okay, advocate for myself because obviously, obviously, ain't nobody else gonna do it. You're your own best advocate. That's what I be telling y'all. Listen up, listen clear. But anyhow, I'll be your advocate. I'll be your advocate. That's okay. Want to donate something to me? Any angel investors out there want to donate a couple of ducats to a sister? I sit up here and open up my own thing and start a community. That's where my heart lies. That's what I need to do. The community resource, I'm an advocate. We're going to get all this shit together and meet your unmet social determinants. All these unmet social determinants out here, they keep on fucking talking about, talking, acting like they have the answers and the fucking solution and shit like that. But ain't nobody putting nothing into action. Nobody's putting nothing into action. They're talking because they know that's what you want to hear, people public. They know that's what you want to hear. They put it all up in their mission and vision statements and stuff like that. And they actually get the money. They have the money. They got the grants. They wrote the proposals and stuff like that. But they're not doing what you think they are. No, they're not. They all need to investigate and audit it. Yes, just like I had told you before, there's a place here, Southeast Mental Health, 16 West Long Street, Columbus, Ohio, 43215. They're actually building a disabled man's building in a disabled mentally vulnerable population person. They're billing this insurance as primary provider, Medicare, for services they never ever rendered. It's true. They're billing for counseling services. He's never ever received any type of counseling service through that place, or anybody that claims that they're a counselor. Never ever in line. They won't be able to show you no type of documentation on a session, on an office visit, or nothing. Some type of fucking counseling services was provided. All right. It's Medicare fraud. That's what it is. So that man, he's actually being discriminated against, which that was turned into HHS N23-513 857. Arthur Salazar and Joseph Ring of HHS, they were to be investigating that particular complaint. And at that time, they were notified that Medicare fraud complaint had been filed as well. And then Arthur Salazar, he wanted to know what date that had been done, because if he didn't have that back by like whatever date he said, he wouldn't be able to investigate the discrimination charge, right? That's what he said. He said it out of his mouth. So what these people were trying to do at that particular point, they were trying to retaliate against the man, because he's always staying on their ass about the dumb shit that they're doing. They're not a bit more patient-centric. They're not at all promoting health and wellness. No, they're not. They're not attempting to reduce complications or anything like that, or potential complications or nothing like that. They're not a bit more linking anybody to any supportive community linkages or any other type of outlet whatsoever to ultimately do what? To ultimately optimize patient outcomes. They're not doing that. They're just telling you that they are, because they know that's what you want to hear. They're telling you on their webpage that they have individualized care plans and shit like that, therapeutic care plans for people. No, they don't. Not a damn thing that they do is individualize it. Actually, if anybody that's a true investigator would go in and look, they would be able to tell. If you're a true auditor and stuff like that. See, we know how to audit records, because we do that too sometimes. See, this is the shit that half these motherfuckers don't know. The Ohio RN that people keep fucking with, it's very, very, very intelligent, number one, but has a lot of experience in a lot of different areas. So it's a lot of expertise involved. Okay. So they keep getting rid of and doing bad shit and mean shit to an actual asset that can really teach them something. Actually, what they all need to be doing is calling the RM back in to pay all the motherfucking money that they stole, everybody, and whatever they've done. They need to pay it, and plus more, plus interest, plus penalties, plus sanctions, plus punitive, plus all that. Pay it off, apologize, and then have her come in and consultant fee and put all these quality improvement plans in place for it. Because each and every person that's been put on Twitter, and I was telling you about here on this YouTube shit, they all need to go back to the table. They all need a immediate assessment of their current processes, their current operational processes. They need an immediate assessment right now, today. There's a lot involved in that. They would have to pay a lot of money though. You gotta do interviews, you gotta do surveys, you gotta do assessments. You gotta look back and you gotta analyze the data. You gotta come back with some recommendations, stuff like that. Then you gotta have them develop a strategic plan and get it in place so they get approved and actually truly be able to just begin to have some processes and things like that and approaches in place that could begin to ever equate to quality. They are far behind. All these people, they're far behind. They're nowhere near true quality. They are lying to you and they're creating illusions. It's not true. And this is why nobody likes Silhan RN. That's why nobody likes. Nobody likes the advocate, do they? Nobody likes the change agent. Nobody likes the person that comes along and says, hey, that's unethical. Hey, that's illegal. Hey, I thought in your policies, I thought you had in your standard operating procedures and policies and shit like that, your protocols and regulations, that it was supposed to go like boom, 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 like this on your fucking workflows and all this shit. I thought it was supposed to go like this. What? You changed the policy, but you didn't go back and do an addendum and you didn't revise it? What the fuck are you talking about? Don't you know that there's legal implications for this? Don't you know you're trying to put my nursing license for the line? And they told me in Nursing 101, they said in Nursing 101, and that's the number one thing that all you nurses out here better take to heed. If I don't tell you nothing, let me tell you this, don't you ever in life put your nursing license on the line for none of these motherfuckers out here. I don't give a damn, none of them. You keep on advocating, you keep on speaking your truth, you keep on standing your ground, you don't let nobody put you in no type of position where your nursing license is taken from you. And that's what they're doing out here, and I'm telling you, all right? Don't you ever put it on the line. You go without. You let them revoke your livelihood. You let them keep beating you down and beating you down, taking every fucking thing that you got. When you can't pay your rent, you can't pay your car, you can't pay your insurance, your lights getting cut off, your water getting cut off. You ain't got shit, but you ain't done shit wrong, nurse. You didn't do anything wrong, nurse, but do what's right for the right reason. They're trying to take care of your population of patients and things like that. And you are really, really a caring, empathetic individual innately, and you really want to see your patients be able to self-manage. All right. You're truly advocating for them. You're truly linking them with resources and supportive linkages, giving them the education. All right. Really sitting and listening and doing true assessment to find out what their goals are, what they want to do, what they deem to be quality of life for them, putting them at the forefront and in control of their own fucking health, because that's what patient-centric is. Not you demanding and being in control of them, and just because they don't want to do what you tell them to do, then you're going to revoke their fucking rights and you're going to discriminate against them. And then if they tell on you to the damn agencies out there that say you can come and tell on us if these people ain't doing XYZ, and we'll investigate, which is a whole fucking lie. All right. They get pissed and want to retaliate because you told on them for the wrong shit they doing. And all you're saying is you need to improve. You need to look in the mirror at what you're doing. This is not what I'm trying to represent. This is not what I'm doing. That's not what's in your mission and your vision statement. You're lying. You're lying to these people, and you're not really helping the community. You're not helping vulnerable populations, underserved and disadvantaged, and you're acting like you're worried about it. You're talking about the fucking health disparities and all that, but you're the culprit. You're the real one. You're causing the health disparities and you're keeping your foot on their neck when they already got unmet social determinants and your fucking piece of shit resources ain't helping them. Fucking somebody named Bernadette's goofy ass over at Southeast Mental Health, 16 West Long Street, Columbus, Ohio, 43215, gonna call a disabled man after he been a patient from February, called him in November talking about she's a fucking case manager after the advocate for him had called 100 times. Like, there's no case management, no resources to address this man's social determinants that remain unmet. They keep complaining. Then finally in November, Bernadette's ass called, and then Bernadette said, when she was asked, what type of resources do you have? I mean, what do you guys have in place? What are you doing with the grant money? Bernadette said, well, we could take her to the food pantry. We could do the food referral. The food referral shit's free. Anybody can do that for somebody. Person could do that for their fucking self. They can get a proxy and have somebody put one order in for them from Hands On 211, and somebody can come and deliver it to them, or they can send somebody that they gave permission to go and pick it up. What the fuck are you doing with this grant money? This person don't need no food pantry shit. And half these food pantries in Ohio, Columbus, Ohio, got molded, wilted, expired shit. The bread, they got a million bags of bread and bagels and everything, and tortillas that damn near got mold starting to grow in it. And they're telling diabetics, get all the bread you want. The fuck? Diabetics, get all the bread you want? And then get you a whole bunch of snacks that's about to go bad and everything like this. Just eat it all, diabetics. Go right ahead, anybody. What? Then you get throwing a bunch of fruit chews as hard as rocks in there. Slim Jims, it's like as hard as damn twigs off of a damn tree in there. Bullshit like that. Where's the healthy stuff? Where's the quality food? They don't have the shit like that. A lot of these places. You know why? Because you're poor. You're in a vulnerable population. They don't give a damn about you. You're poor. They'll eat it. They'll eat it. Give it to them. It's rotten. It's moldy. They'll eat it. They'll eat it. Give it to them. It's expired. Who cares? It ain't gonna kill them. And give it to them with cans all beat up and smashed. Botulism. Give it to the poor. Give it to the vulnerable population of disadvantage. Give it to them. They need to be doing a true assessment of all these individuals that's coming in there. Quick assessment. We need to get what your preference are. Okay, they give them buzzers, bags of hot dogs and shit like that. What you doing? I'm busy doing something. What is it that you need?